All right, so moving on to risk reduction sentences, and I just skipped over the slide on it, so let me see if I can. Risk reduction sentences start October 1st, right, for sentences starting next week. The judge is going to be, when they sentence a defendant to a bifurcated or a TIS sentence, the court can decide that they want to do a risk reduction sentence. In that case, the DOC will do an assessment, which the defendant has to agree to cooperate in, and they will assess their risk for reoffending and their criminogenic factors. And then they develop a treatment plan, supposedly sort of an individualized treatment plan, to address the factors specifically identified in the risk assessment that would, contribute to the risk of recidivism or the dangerousness of this particular person. If you have a risk reduction sentence, you potentially can get out at 75% of initial confinement if you complete the programming recommended in your treatment plan. The unserved confinement time, unlike other adjustments and what has traditionally been adjustments like challenge incarceration or earned release, it goes away. It just goes off into the ether. It doesn't get added to your ES. There's a 30-day court notification, but there's no court veto. Because the idea is that the court's decided this up front at sentencing. All right? There are certain excluded felonies, and there's a list of excluded felonies for all these things, and it's going to be something you're going to want to sort of keep a hold of and have in your briefcase or whatever. In the Legislative Fiscal Bureau July 29th memo, which is in the materials, there's like a 8-page list of every felony and which of these things it applies to: the positive adjustment time, the risk reduction sentences, other things. So it'll be a good thing, obviously, to consult on a regular basis. So bifurcated sentence modifications. This is somewhat similar to what we talked about before with the petition for court for sentence adjustment at 75% for Class F through I felonies and 85% for Class C through E felonies. This is still going to exist after October 1st, 2009. But those are only going to be for sentences imposed before that. So in other words, a TIS person who's been waiting to get his 75% petition in, they can still do it, but they can also choose the new option if they want. The new option will be for DOC to release an inmate early onto ES if they're serving time for a nonviolent F through I felony, and there's going to be some input by the agent of record or the prison social worker that says, this person's going to be a good candidate for getting out with non-assaultive behavior on the outside. And then when the person's within 12 months of ES, they can get out on ES early. So this is going to be, I think, big for people who are serving short sentences, right? I mean, this is going to be potentially, you could get a 1/2 time cut, right? I mean, if you're serving a 2-year initial confinement sentence and you've convinced them that you should get out on ES early after you've served a year, then you're within 12 months of release on ES, you could potentially get out with a 1/2 time cut. Or like on an 18-month initial confinement sentence, I suppose, on even more so. So that's the sentence modification part of it. I think that's going to be probably something that's going to add up to time cuts for a lot of these people who, for whatever reason, they got a prison sentence up front, but the DOC, they're just aching to get these guys out of prison because they really just don't want them there. They don't need to be there. They're not a big risk to reoffend. They're nonviolent offenders. They just want to get these guys out. Your forgery people sentenced by judges who just hate forgeries or whatever, that type of thing. So then there's going to be changes to the earned release and boot camp, and these are fairly straightforward. They're just going to be expanded to allow more people to get into them because you don't have to have a specific drug problem. Boot camp is going to, and the language is right in there in 302.045 or whatever it is on the boot camp. Just look at it. It says they have to identify other treatment needs that are directly related to their criminal behavior, but not necessarily drug problems that they have. And it's real clear if you look at the DOC stuff on this that these programs, they're making it real clear, are set up for assaultive, nonviolent offenders.